Hello and welcome to our webinar Online Counterfeiting and the Role of Platforms to be or not to be responsible. For those of you who don't know Novagraph, we are a member of the Questel Group and we are a historic international firm of industrial property attorneys offering both legal and administrative services. Novagraph manages over 1 million intellectual property assets on behalf of its clients and represents many of the world's leading patent and trademark owners. Our headquarters is in Amsterdam, Netherlands, and we have offices in Europe, including London, Brussels, Paris, Geneva, as well as in the USA, China, and Japan. Let me introduce myself. I'm Marc-Emmanuel Mellet, legal counsel and head of the domain name and internet department. And I'm joined today by Alexandra Maggio, trademarks and design attorney. Today, we are hosting a webinar dedicated to monitoring and protecting trademarks online. First, we will look at what European case law has taught us about the liability of platforms for the distribution of counterfeit products. We will then look at how to detect and protect against counterfeiting on online platforms. And finally, we will present our monitoring tool using an example of a brand to show you how you can take the quickest action to stop infringement of your rights. A Q&A session will bring this webinar to a close. I will now hand over to Alexandra. We will take you through the current state of case law on platform liability.
So good afternoon or good morning everyone again. So I will begin with a few words about the impact and the scope of trademark counterfeiting. And like most of you probably knows, it's a big risk for the health and safety of the consumer, and it's also a lot of loss of revenue for company. And we have a report from UIPO and OCDE showing that the global trade in counterfeit amounted to 412 billion in 2019. So it's quite a lot, and it's 2.5 of world trade. So, and the main country of origin, what not a surprise, China, Turkey, and the Emirates is also really important nowadays for counterfeiting distribution. So, of course, with the pandemic, we have seen a big rise of e-commerce and a correspondence also with the online counterfeiting. And we have again one report from UIPO and OCDE showing that the percentage of people using the internet could be one of the factors explaining the rise of counterfeiting. So, like everyone could think, to report comparing the importance of internet for facilitating the trade of counterfeiting goods. So, and what is really special as regards online counterfeiting and infringement, it's of course it's difficult for the trademark owner to locate the infringers, and that's why many right holders are attempting to seek the liability of platform as intermediaries. So, and online counterfeiting is not only on, let's say, the dark side of, it's not dark web, of course, but of the bad website you could find in the report of the US trade representative, but online counterfeiting can be everywhere on normal platforms like eBay, Vinted, or Amazon. So that being said, platforms play a big role, at least a passive one, in the distribution of counterfeiting. And it's difficult for trademark owner to identify and locate the seller. That's why they are trying to set liability of the platform. However, the case law, especially the European, the one from the ECJ, is rather hostile to set liability. Even if some other evolution could be highlighted, and that will be done the structure of the the case law review. So the first part will show that it's difficult, if not to say almost impossible to engage liability of platform for diffusion of counterfeiting goods. We have a quasi-automatic exoneration of platform liability due to the absence of use of third-party trademark by itself and as technical intermediary without active role or behavior. Then we have the possibility to set the liability in respect of trademark law, and then in this kind of liability, the question of trademark use and use of the trademark integrated in the platform or commercial communication will be crucial, and in a global law approach, we will again seek for the active role or behavior of the service provider or publisher of content. In part 2, we will then discuss shortly, because we don't have much time, if we are going to more responsibility or accountability. So main point, if you only could keep this point, then it will be fine. We have a tricky issue of use of trademark by platforms in the sense of trademark law. And we have also to remind that it's a responsibility for published content or data stored. It's only for service provider with a purely technical, automatic, and passive role. That means that they don't have any knowledge or control of the stored data. So, and this active role could be then opening liability if, again, this active behavior or role of the platform as regards the data stored could be established. So, a really important text, you could read it in the presentation, which will be sent to you. And then first case probably known from everyone is as regards keyword advertising with Google Ads, and Google has been considered as responsible in France, and then after the file has been brought to the French High Court, the Cour de Cassation, who decide to stay for preliminary ruling, sorry. And the question was, could Google be responsible as liable for counterfeiting because of use by himself of trademark sold as a keyword to an advertiser? Keeping in mind that Google is not controlling the commercial communication of the corporation. And finding this liability as infringer, the question was to know if Google could be liable according to the general rule of liability of service provider. We were then seeking liability of the referencing service provider as such, and the ECG say quite quickly, no, there is no use by the internet referencing service provider of the trademark of other in the requirement of trademark law, and neither liability according to e-commerce, the e-commerce directive has been considered. So it's quite difficult then to seek the liability of platform after this decision, and the service provider cannot be held liable for the data which it has stored at the request of an advertiser unless having obtained knowledge of the unlawful nature of this data, and if the service provider failed to act expeditiously for removing this the concerned data. So again, we have this notion, this concept of active role cooperation of the platform to be reactive for putting away the contested data. So again, I will insist: no active role, no liability, unless refusal to cooperate by removing the advertising identified as illicit. As we got active role, which is then a question of fact and always observed by the court, it's if the services you have to pay for the services, it could be not enough for having an active role. On the contrary, if the platform is helping with keyword selection and writing the advertising, it could be an element to keep in mind for concluding to active role and then to liability. So this concept is really important, is really crucial, but it's not always easy to address, and it's changing because it's at the discussion of church. So we have a casuistic approach. And then we have the eBay case, and in this case, eBay was considered at the end as liable as regards the responsibility of service provider, because the platform helps to optimize and promote offer and provide assistance to sellers. So the active role has been considered as constituted. So, and the exemption from liability was not accepted. So, and the key point again is that we have a concrete approach, and the ECG calls on national church to carefully examine the way of working and functionality of the platform. So at the end, we could have maybe so many models of liability as platforms. So then in France, for example, we had a different approach between two courts for as we had Airbnb. For the Court of Appeal of Paris, Airbnb was considered as having an active role because it was helping the prohibition to hands, and for the second in Aix-en-Provence, it was actually the opposite. So it's not so. It illustrates the difficulty and the importance to evidence the way of working of each platform. So again, back to ECG with Amazon. And the question was, what about the storage of goods? Could this lead to use of trademark by the marketplace himself and then to liability as infringer? And again, the ECG, quite in favor to platform, say no, even if Amazon, as regard the opinion of the Advocate General, could be considered as going beyond mere warehousing. The ECG said no, there was not active behavior from Amazon, and no liability was possible under trademark law. So a person who, on behalf of third-party stores goods which infringe a trademark, with being aware of its infringement, must be regarded as not stocking those goods in order to offer them and to put them on the market himself. So as a conclusion of the first part, it's not so easy to have to see the platform as liable unless active behavior, which is really a key point of this presentation, and use as part of an own commercial communication could be evidence. So even if it's not excluded, the conditions of liability are quite difficult to meet, and some frustration from right holders has been noted. In this context, we had last year the really famous Amazon Louboutin case, which could have been considered as a door open for more liability for a platform. And again, it's not a reversal case, because again, the court had a concrete look on the way of working of this platform. And the question was whether Amazon was making unauthorized use of the Louboutin trademark by integrating alongside its own offer, presented in the same manner, which was quite important, the offer of third-party seller, and by proposing as well complementary services, such as storage, transport, and shipping of the good could lead to responsibility. And the ECG say that the direct use of trademarks by Amazon could be possible, and therefore Amazon could be possible, and which this will be done determined with the referring national court. And again, actually, the active role and the integration in own commercial communication have been really looked by the court, and something quite new, not new as regards to mark law, maybe in this question of liability of platform, was that everything should be, the court said that everything should be assessed in light of the average consumer use or internet user perception. So this this perception of the average consumer is really crucial, and everything must be seen with the eyes of the average consumer. And of course, like everyone will have to ID, it's not so easy to know who is the average consumer, who will this average consumer react by reading an announcement, an advertisement on the web. Will the average consumer be more concentrated, on the contrary, not so concentrated, because you have a lot of pop-up in the web, so it's not so easy question. But still, again, really important, the concrete factor and how the platform is working has been determined in this case. And the ECG, having a look at the fact, gives some example which can tip the scale in favor of platform liability. The uniform presence of all offer by displaying all advertisements together with those of third party and adding the own logo is something really important, and probably some of you are using Amazon and could remind that the announcements are presented in the same manner with the logo from Amazon, and you have written in small Amazon trademarks or not, but it's not actually, it's not so easy to save as maybe an internet user. And the ECG invites the national code to have a look on the complementary services proposed by the platform, the storage and the dispatch of the good, and to have a look as well if the platform is providing customer care service, such as dealing with questions. And all this kind of services and a way of presenting the advertising could bring us to the conclusion that the platform is having an active role and that could be responsible for as an infringer or as not a service provider, but a publisher of content. And again, I will insist to the perception of the average consumer, which has been really put into the light in this Amazon decision. And like I said a few minutes ago, this kind of approach is classic, is usual as regards trademark law, but it has also to be noted that it is the same reasoning as the one we have now in digital services, who is into force as regard the big platform since August last, and will be in force for every platform, every online intermediary in February next. So the DSA keep the principle that host providers are not liable for content stored on their server, but if it is likely that the average internet user could establish a link between the content and the platform, the exemption of liability will not be possible. So we have the same logic as in the Amazon running. And as a conclusion, we could see that we have a kind of encouragement from the ECG, from the court, from the European Union to the platform to be responsible and circumspect in the drafting of the announcements. Let's see if Amazon, after the Amazon and Louboutin case, will change the presentation of the announcement to differentiate the Amazon good from the other, but we will see. From the time being, no change in Amazon presentation of advertising. Maybe after the case will be decided by the national court in Belgium, in Luxembourg, in the Louboutin case. So the case law and the text invite us not to take into account only the platform ability to know and control the contents, but also the active role upstream and downstream of the online publication. So, and we see that the evolution could be, as well with the DSR, to accountability for platforms, for inviting them to be more responsible and for giving consumer confidence. And we have also some platforms like Amazon trying to be more responsible in order to maintain consumer confidence. So, and Marc-Emmanuel, we will take the floor now. We'll also present you some mechanism of reporting infringement on platform and specific procedure. We could also be a way to fight against counterfeiting.
Thank you, Alexandra. As Alexandra pointed out in her presentation, it's very difficult to hold counterfeiters liable because they are difficult to identify. But it's also very difficult to hold platform legally liable. So to obtain the removal of infringing content, namely counterfeiting goods, it will be necessary to make the platform accountable. So we will see how to detect counterfeiting on online platforms and protect your trademark. So to protect your trademarks and products on online platform, it is important to do three things. Monitor, prevent, and act. Monitoring is the most effective way of detecting infringing content. As Alexandra pointed out in her presentation, some platforms have set up procedures for reporting infringing content. And finally, once a counterfeiting good has been detected, action must be taken to remove it. So how do you discover that you are being counterfeiting an online platform? All too often, a company discovers that its products are counterfeit as a result of customer feedback. Indeed, an unhappy customer will contact your customer services explaining that they are not satisfied with their order. Detecting the presence of counterfeit product can be the result of internal team research. Our client legal department frequently send us advertise of counterfeit products which have been detected by the marketing department, for example. But these are only indirect way of detecting counterfeit products online. If you want to find counterfeits on platform, you have to go looking for them. Searching is what you find, and the best way to do this is to implement platform monitoring. There are two main types of monitoring: manual and computerized monitoring. So the manual monitoring is inexpensive and allows you to detect the most annoying content. This will be the content few potential customers are mostly likely to come across. However, this type of monitoring is time-consuming and often incomplete. On the contrary, computerized surveillance monitoring is now very comprehensive. We can monitor not only terms but also logos or shapes. It's also possible to detect a brand in a text, but also in photos with or without filters. It's also possible to detect similar terms. This type of monitoring is faster and more complete than the manual monitoring. As Alexandra was saying, we are seeing a growing sense of responsibility on the part of the platforms, which are seeking to give the public a good image and show that their platforms are secure and that they are fighting against counterfeiting. For example, eBay with a program which provides the ability to create a profile page to share active rights information with users and then makes it easier to report infringing products. Second example with the project zero of Amazon with search for potential counterfeits based on key data points provided by the right holding company. Ability to immediately remove infringing products without the need to contact Amazon, and automatic blocking of violation. Finally, once you've monitored the platform and registered your right with them, it's time to take action to have infringing content removed. Indeed, as Alexandra said, it's difficult to hold the seller and the platform liable. So to combat the presence of counterfeit ads, it will be necessary to prioritize action to obtain the removal of such content. The quickest way to take action is to send an email to the platform or to file in an online form. In such requests, you need to be as precise as possible, clearly stating your prior rights and explaining why the products in question are infringing. Assume that the platform's legal department will not carry out any further checks. Today, thanks to technology, it's possible to automate some of this action. We will now demonstrate our monitoring tool with an example. For this webinar, we use the example of the well-known sports shoes brand On Running. Indeed, On Running offers shoes model with a cushion soles that are easily recognizable. On the right, we have reproduced the original model of the basket, and on the left, the result detected by our monitoring tool. This is an identical reproduction of the On Running sneakers sold on the AliExpress platform. So this slide shows an overview of our platform for our example. Our software, we will take over the URL. You will see a screenshot of the platform. Other screenshots will be taken automatically by the software to track the progress. On the right of this slide, you will find a brief description of the case and the recommendation. And at the bottom of the page, you will find the type of infringement, and in this case, you will find also the possible action for this platform, and which are configured in our software for almost all existing platforms. In this case, there are two forms and the option of sending a formal notice by email. When you click on the IP report there, you will open the present abuse request, and our software will provide us with a draft of the content to be included in the request. For example, our customers' trademark, the infringement, the legislation, and by clicking on the Cs and Ds demand, our tool will automatically generate a draft with the address to write and the content of the letter to be sent, which will contain the customer's right, the legislation, etc. This partly automated solution can be used to send out a large number of letters and requests in order to obtain rapid removal and of counterfeit in the shortest possible time. Finally, we wanted our tool to adapt to all companies. We know that every company is different and requires different intellectual property strategies. Thus, it's possible to adapt monitoring both geographically but also on a different platform. It's also possible to monitor social network application or even web pages. Furthermore, our tool uses technology to be able to process a large number of results and act accordingly, However, at all stages, a specialized lawyer intervenes to adapt the strategy. Finally, we have put in place indicators so that our client can measure the impact of our work. It's therefore possible to obtain the number of counterfeits dedicated, but also the number of action launched and their results, and to filter by territory, by brand, by platform, etc. So it's the end of this presentation. The presentation has been recorded and will be sent to you by email. And we will go for the quick Q&A question after a quick conclusion.
Yes, and the conclusion, only a few words to remind you again that it's not so easy to engage the platform liability, but it's possible, and we can hope that it will be more and more possible because now the ECG has actually constructed case law, which with this notion of active role and integration of the own commercial communication of the platform could lead to liability, and we have also a trend for the platform to be more responsible. Because everyone says that a lot of counterfeiting are circulating on the web, and we need to have a web more secure. And don't forget, in this respect, to monitor also your brand. So, do you have some question?
Alexandra, we have a question. Does the DSA repeal the e-commerce directive?
No, actually not. The e-commerce directive, you can find it in the slide with when the presentation will be sent to you, remain in force, and the DSA is completing and amending some points of the e-commerce directive. And like I said during the presentation, the main point is that the principle is that the service provider as such as technical intermediary is not liable for the data stored. This is maintained and this remains.
We have a second question. How much does such a tool cost? So the answer is not easy to answer. The question is not easy to answer. The costs vary widely depending on the company, the brands monitored, the channels monitored, and the number of results. For the main module, namely online platforms, social network, website, we can estimate a cost of around 1,000 and 2,000 euros per month per module for the brand monitoring. This monthly subscription includes both monitoring and action, which put the cost into perspective. And if we don't have more questions, we will end the webinar.
Yes, we will send it probably tomorrow, the link and the presentation. So you will have everything and then more than what we have said, because we need to be quick. So, and last word, to say that again, as regards the liability from platform, is not easy to engage them, and it's also because the court and the tax are always looking for a compromise between the interest of the development of the economy of the internet and those of consumer and of trademark owner. So it's always looking for a compromise.
And if you have more questions, you can send them by email. You will find the email address in the PowerPoint. So don't hesitate. We thank you for your attention.
Thank you. Have a nice day or nice evening. Bye-bye.
Bye-bye.